Good night, I'm going to talk about the sources of commercial law. This branch of law creates a broad yet flexible system that seeks to balance state legal security with the autonomy and speed required in business. At the top, we have mandatory rules. They protect public orders, consumers, and fair competition. Then come the supplementary rules and contractual agreements, which give flexibility and allow parties to adapt their relationships. But the most distinctive feature is commercial custom, a formal source that helps fill illegal gaps and shows that commercial law is a living, evolving body influenced by globalization and digital trade. In short, the coexistence of right and law, custom, judicial decisions, and private agreements keep commercial law relevant and effective in a constantly changing commercial world. General objective: to analyze the sources of Colombian commercial law, identifying their hierarchy, legal basis, and practical application within the commercial regulatory system. Specific objectives: to define and explain the sources of commercial law, both formal and material, according to Colombian legislation. To identify examples of the application of these sources in the commercial code and other legal instruments. To explain the custom, privilege, contra-legion, and second-legion, exemplifying their application in Colombia and indicating which ones are permitted or not. Hello, my name is Maria Camila Girado, and I'm going to talk about the formal sources of commercial law in Colombia. First, commercial law has different sources that give origin to the rules governing business activities. The formal sources are the ones that actually create legal norms, while the material sources just influence their creation through social, economic, or political factors. The first formal source is the mandatory rules. These are laws that must be followed and can be changed by the will of the parties, because they protect public interest and fairness in commercial relations. For example, Article 98 of the Commercial Code says that every company must be created through a public deed and registered in the Chamber of Commerce. The second source is the supplementary rules. They apply when the parties haven't agreed on something specific. For instance, Article 905 says that if the contract doesn't mention the place of delivery, it must take place of the seller address. Then we have the contractual agreements. According to Article 822, every valid contract becomes the law between the parties. So, if both sides agree on a confidentiality clause or a penalty, it's legally binding. Another important source is the commercial customs. It is a practice that's publicly repeated and accepted by merchants as binding, as long as it doesn't go against the law. For example, the common use of promissory notes or electronic invoice. We also have jurisprudence, which means court decisions that helps interpret the law, and doctrine, which refers to the studies and opinions of legal experts. In short, these formal sources work together to make sure that commercial relations in Colombia are fair, consistent, and adapted to the real business practices.
Material sources are the economic, political, social, and technological factors that inspire the creation of new legal norms. For instance, the rise of e-commerce, globalizations, and international transactions has encouraged legal reforms to protect both consumers and entrepreneurs. Now, in the commercial law, we can also find a clear hierarchy of sources. At the top, we have mandatory rules, which must always be followed. Then come supplementary rules, used when no specific agreement exists. Next are contractual agreements. Here parties set their own terms. After that, we have commercial customs, followed by jurisprudence, the interpretation made by the courts, and finally doctrine, which included opinions and studies from legal scholars. This hierarchy shows that the law remains the main foundation of commercial law, while custom and judicial interpretation still playing an essential role in the real-world applications.
An analysis of the source of commercial law reveals a broad flexible regulatory system, which judicial order is designed to balance state legal certainty with the autonomy and speed inherent in commercial transactions. The premise of mandatory rules guarantees public order and collective integrity, such as consumer protection and competition rules, with the existence of supplementary rules and the contractual agreements grant the necessary leeway to the will of the parties. However, the differentiating and most characteristic element of this branch is the welcoming of commercial custom as a formal source capable of filling legal gaps and complementing the lab. This demonstrates that commercial law is a living body, constantly influenced by material source, e-commerce, and globalization that drive the creation of new rules. Ultimately, the proper application of commercial law depends on an understanding of this hierarchy, a pyramid within law coexists and is complemented by private judicial interpretation and private agreements, ensuring that the legal framework remains relevant and effective in the face of the relentless dynamics of commerce. Thank you.
Custom privilege, supplementing the law. Definition: custom applied when there is no legal rule governing a specific case. It serves as a supplementary source to fill legal gaps. Colombian example: the use of promissory notes and bill of exchange in banking practices before being detailed in the commercial code. These customs were later recognized and incorporated in the legislation. Validity in Colombia, permitted as it does not contradict the law and fill its absence. Custom secundum legem, supporting the law. Definition: custom that coincides with or complements what is provided by law, reinforcing its application. Colombian example: Article 3 of the Commercial Code recognizes commercial custom as a valid source when uniform public. For example, the custom of charging interest on commercial credit operations, consistent with the central bank's maximum interest regulations. Validity in Colombia, permitted as it complements and reinforces legal provisions. Custom contraligent, against the law. Definition: a custom that directly opposes the provision of the law. Colombian example: charging interest rates higher than the legal maximum, usury. Although common in some sectors, it is provided by law. Article 305 Penal Code Law 599 of 2000. Validity in Colombia, not permitted as a contraries express legal norms.